Hello friends, thank you very much for watching my a little longer videos, because if I have to state a legal position, it will take time and you will have to watch the entire video to take home the meaning that I wish to convey. So if a talk has to be done in 1 hour, I cannot make it concise in 3 minutes. It's not possible. Today's video, on demand of many of my colleagues, is on newly inserted section 74A of CGST Act. 74A replaces section 73 and 74. And these sections 73 and 74 shall remain valid up to 31st March 24. So all notices for recovery of tax, interest or penalty under 74A will have to be given under section 74A. 74A does away the distinction between 73 and 74. So the litigation that we were all doing in high courts challenging show cause notices under section 74, in my opinion, is gone. Now, one notice will serve twin purposes of non-fraud cases and the fraud cases, hitherto covered by section 73 and 74. Now friends, three main issues which as professionals we must know. First is the limitation. Limitation is 42 months from the date of filing of annual return for recovery of tax and 42 months for recovery of erroneous refund. Now for recovery of erroneous refund, annual return doesn't count. It's 42 months from the date when refund was given in your bank. So that is the meaning of limitation. And the order should be passed within 12 months from issuance of show cause notice. That is, this 42 plus 12, 50 more 4 months plus 6 months of extension given in 74A by the order of Joint Commissioner is the maximum limit. But if show cause notice is issued within 12 months from the end of the year, that is not within 42 months, then the adjudication order has to be passed within 12 months from the end of 12 months. Because the adjudication order limitation is linked with date of issuance of show cause notice, not with the date of filing of annual return. So this is an extremely critical difference, which as lawyers we must appreciate. That's very, very important. So if a show cause notice is issued to you after 1/4/24, that under section 73 or 74, that notice shall be invalid, because those sections do not remain in the books post this date. And therefore, you can challenge this notice as illegal and without authority of law. Now, under 74A, the penalties more or less remain same. The more or less the waiver is same, except that if self-assessed tax or amount collected as tax is not deposited within 30 days, even for non-fraud cases, the penalty shall be impossible. Whatever the percentage, you can go through the act. So you have to remember it very carefully that penalty even in non-fraud cases in the 74A may be impossible. Now many people ask me whether penalty under section 122 can be independently levied when there is no recovery of tax or interest under section 74A. Well friends, if penalty is levied under 74A along with tax and interest, then 122(1)(a) cannot be invoked. However, the penalty proceedings under section 122, in my view, are independent of section 74A or 73-74, because these sections cover only 3 parts: tax short paid, not paid, the ITC wrongly availed or with fraud, or the refund taken in a manner which was not good, which was not legal. But 122 covers many other aspects. Therefore, the penalty under section 122, in my view, shall be independent of section 74A after 1/4/24 or in 73/74 prior to 1/4/24. Now, in the case of Patanjali, Allahabad High Court had confirmed this. This is a civil penalty, not a criminal penalty. Of course, matter is now sub judice before Supreme Court. Supreme Court has stayed the matter of the judgment of Allahabad High Court in Patanjali case. Now, what is the legal strategy to be adopted? So, whenever you get notice after 1/4/24, strategically you have to see whether the notice is issued under 74A. If yes, then from that notice count 12 months. If order is not passed, and extension by 6 months by the Joint Commissioner has to be before 12 months end, not after 12 months end. So if the extension of 6 months is not taken by a proper officer before a period of 12 months expires from date of issuance of show cause notice under 74A, then you must file a letter with the proper officer that the proceedings are time barred. He cannot take under law a post facto extension from Joint Commissioner or from court or from even Supreme Court, because the matter gets time barred. If matter gets time barred, the proceedings becomes non-est. Now, the other fallback of this single section 74A, section 73, 74 go away, is also a loss to the profession. Because earlier under 74 notices, we could say whether the proper officer has been able to make out a case for a fraudulent transaction or not. Now all this goes away. So the show cause notice and consequent high court litigation go away. This is the proper officer who will decide based on facts and analysis of law whether you committed a fraud, you did not commit a fraud, and accordingly take action. Now, the one more fallback of this particular provision is that for fraudulent cases, the limitation is 3.5 years to pass the order. Whereas for non-fraudulent cases, the period is 5 years. So this is a kind of a dichotomy, in my view, where so-called honest taxpayers who commit irregularities in terms of non-fraudulent cases, they face a wrath of 5 years, whereas people who were fraudulent, they face a far lesser limitation. But there's a logic, because the people who commit frauds, they may run away. So therefore, the legislature may have thought that a shorter limitation will do good there. Other thing is that the powers under section 132 or the proceedings under section 132 remain. They do not go as it was earlier in 73, 74. One more issue is, there's a phrase used, amount of tax collected. So this word collected has to be interpreted. So if you issue a bill and put in 3B, where you have charged the tax, does it amount to collection? So the penalty will be levied if you do not deposit the amount collected as tax within a certain period as per section 74A. So whether just reporting in 3B a tax invoice, will it amount to collection, or after the buyer has given money including tax and you don't deposit, then this penalty will be invocable. So this is an interpretation which we shall all deal with in times to come. Well friends, this is section 74A. God bless you. Watch this video. I repeat, these videos cannot be smaller videos if you have to understand the law. God bless you. Happy New Year.